Mr. Fletcher, is the coercion encouragement framework out of Bantam book the only way to look at this case?
So I think there are two ways to look at this case. I think one of them is the coercion inquiry, which we think comes from Bantam books. You can think of that as an aspect of state action because when private parties are compelled to act, as the court said in Halleck, they become state actors. We think that's the right way to think about this case. Respondents in the lower courts have also proposed a different way, the state action way. They've suggested that even absent coercion, the government speech, if it encourages in some colloquial sense private action, it can turn that private action into state action.
Do we just so I understand your argument, do we normally apply state action doctrine in cases involving the government or private parties?
Both, I think. You know, in some state action cases, you're asking someone is suing a private party and alleging that that private party is bound by the contours of the First Amendment or other constitutional provisions because they're state actors. You see some suits like that look like this, suits against the platforms, suits against Stanford University, which is referenced in its amicus brief here. But you also see suits against the government based on conduct by private parties. That was the case in Blum, and that's the theory that respondents are pursuing.
Are there any First Amendment cases?
Any First Amendment cases, I'm sorry.
Employing state action doctrine.
And suing the government. Off the top of my head, I can't think of one.
So they're usually things like Medicare or government contracts or relationships like that.
Yeah, and I think what that gets at is that it's very unusual, and we don't think it's possible for the government through speech alone to transform private speakers into state actors. We think these cases usually are and ought to be viewed through the Bantam Books type framework, where there's a problem if the government is engaged in coercion, but if it stays on the persuasion side of the line and all we're talking about is government speech, then there's no state action and there's also no First Amendment problem.
One final question. You continue to refer to government speech. Just for my edification, what's the constitutional basis for government speech?
Yeah, so the court has said, I think, that the government is entitled to speak for itself. It's not a right that comes from the First Amendment. It's a feature of our constitutional democracy. As the court has said, the government couldn't function if it couldn't express points of view. In Walker, the court explained, for example, that the government has to be able to run a vaccination campaign at times of public health crisis. I think that's a major part of what was going on here. So the court hasn't located it in any specific constitutional provision. It's just part of democratic governance.